Thank you very much, ladies and gentlemen. Our next speaker is Andrew Verspaandonk. Since coming to the bar on Michael Green's list about 12 years ago, Andrew has developed a very busy and highly successful wills and estate and property practice. On a personal note, again, I thoroughly enjoy being opposed to Andrew or mediating him because he has particular qualities of being forthright, determined, dogged in an excellent manner, and always putting the best interests and case of his clients forward. I am sure all of you would agree that these qualities of a barrister and a solicitor are in the best traditions of the Law Institute of Victoria and of the Victorian Bar. Ladies and gentlemen, Andrew Verspaandonk.
Thanks, Georgina. Good morning, everyone. There's always good news and bad news. The good news is you've had an excellent update across the states from John Nunns this morning on probate law generally. The bad news is that I've lost my glasses. So if I stumble, just cut me a little bit of slack. Just referring to one case that John referred to, though, the Ademption case of Simpson and Cunning, you should be aware that there's been another development in that. In the New South Wales Court of Appeal in March this year, there was a case of RL and New South Wales Trustee and Guardian. And although it was obiter, Justice of Appeal Campbell went on for, I think it was something like 80 paragraphs explaining why the Viatel line of authority is wrong and ought not be followed. Now, it didn't matter in that state because they had some legislation which achieved the same result in any event. But as far as I'm concerned, in Victoria at the minute, the law is extremely uncertain. And if you want to know more about that, the Leo Cusson Wills and Probate Conference, which is coming up in a couple of weeks' time, has a section on that aspect which I'll be delivering. But you should just be aware that Simpson and Cunning is a single judge decision of the Victorian Supreme Court, and it's effectively been disapproved, although on an obiter basis, by the New South Wales Court of Appeal. RL and New South Wales Trustee and Guardian, 2012 New South Wales Court of Appeal, I think it's 39. I think it's decision number 39. Okay, just in terms of my presentation this morning, I describe it as family provision developments. They're largely Victorian cases, and it's something of an update. There are a few 2012 decisions, but I know at least one of you, and I apologise to you in advance, David, has heard substantially this talk before. What I have done is gone through some decisions over the last couple of years and just looked at things which I found interesting and created points which I thought were worth emphasising. Now, the first case, just moving it along, because I guess we're running a little bit behind, that I want to talk about, and I think it's an important one, is on page 1 of the paper, paragraph 2, under the heading Responsibility to Provide, and that's the Whitehead and State Trustees decision. Basically, the gist of this case is that it is now crystal clear that the old category-based entitlement to claim under Section 91 of the APA has been well and truly consigned to history. The two claimants in this case had somewhat unusual relationships, particularly the first claimant. It involved an elderly man who had a relationship of sexual intimacy and companionship with a much younger woman. They lived in separate houses, though their houses were quite close by and they saw each other a fair bit. She had a son by another man during the currency of that relationship. It doesn't appear to have been a de facto relationship or in any sort of exclusive sexual relationship. And she was considering having an abortion, and it was accepted that the deceased had told her, don't do that, you have the child, I'll look after you, I'll make sure that you're provided for. So when he died with a very old, out-of-date will, which left everything, I think, to his siblings, she made a claim and her son made a claim. She made a claim on the basis that she was his friend and companion, and also she'd been told basically to continue with the responsibilities of parenthood and he would provide for her. That was her claim. The son's claim was essentially, her son's claim was essentially that he treated me like a son, which the judge found to be quite correct. And on that basis, provision was made. But the thing that I found really interesting in this case is that for the first time since Schmidt and Watkins back in 2002 in Justice Harper's decision, there was an extensive discussion about what the new legislative provisions, the 97 legislative provisions, really meant in terms of eligibility. You'll recall, of course, that you used to have to be a child or a spouse to make a claim. In 97, that changes to a category of person for whom there was a responsibility to provide. And Justice Harper back in Schmidt talked about that and said, well, look, you can't look too far away from the source of all this, the purpose of this law, which was for intimate or close family members. Justice Bell, I'm over at paragraph 7 now, at paragraphs 21 to 29 of his judgment, looked at the way in which the legislature had decided to expand the class of claimants and basically said, look, it was well considered. There'd been a wide process of law reform discussion going on across the country, and Dr. Atherton from the University of New South Wales really decided that the old category-based system wasn't appropriate and there should just be this general rubric of being owed a responsibility to make provision. So this case for me emphasises heavily the truth now that no one is in and no one is out in terms of eligibility to make a claim. Obviously the facts will vary from case to case, and as cases proceed and go to judgment, I wish a few more of them did go to judgment, you'll get an idea of the kinds of claims which tend to be successful and the kinds of claims which don't. But as I said, I think it was Justice Mandy and Petrucci a few years ago, Justice Grigoriou more recently in the Corbett case, which we'll look at a bit later, and now Justice Bell has said, look, you can't just say that person cannot ever succeed because of the relationship they bear to the deceased. So that's the thrust of that case. And I relied on that case fairly heavily in an application for summary dismissal, which I was defending, which we'll talk about a little bit later. Now, I'm now on page 4 of the paper, and that leads me to the unhappy topic of summary dismissal. The effect of this section, this next, 5 or 6 pages, can be summarised in 3 words: just don't bother. I say that with some force, a little bit of bitterness. I'm still in therapy from losing a couple of these strikeout applications because we all got excited when Associate Justice Mukhtar struck out the claim in Jackson and Nunns. You will recall that was a case where a nephew brought a claim against his wealthy uncle's estate. He'd been left $250,000, I think, or no, it was $150,000, which is, you know, a reasonable amount of money in anyone's book, I guess, but I think the estate was worth about $1 million, and he figured that wasn't quite enough. So he ran the basic claim on the basis that, look, my relationship with my dad wasn't much good. This was the guy that really took over. He was akin to a father to me. And Shane Newton, being Shane Newton, threw down the gauntlet and said, right, we're going to strike you out. Went along and submitted essentially that a great relationship between an uncle and a nephew doesn't create an obligation to make provision for that nephew. Associate Justice Mukhtar agreed and dismissed the claim. We all got terribly excited at that point, and the other thing which encouraged us was Section 63 of the Civil Procedure Act, because Jackson and Nunns, the claim was dismissed under the old test, which was harder for a defendant to establish, had to be practically unarguable, and that's a hard thing to demonstrate. The Civil Procedure Act now provides that a claim can be struck out if it doesn't have a real prospect of success. So the bar was lowered and a few applications were brought. The first of those that I brought was the application in Wallensack I'm at paragraph 16 on page 6. This case just demonstrates to me that if you die in this state without children or a spouse, you're likely to find that your estate is challenged by just about anyone. And unfortunately, the commercial pressure on defendants is that you're likely to get some money if you are that challenger, even on a commercial basis. This was an elderly Italian man. He didn't have any wife, didn't have any kids. He left a will, basically leaving everything, or almost everything, to a wealthy niece who was his favourite, who was my client. His sister was left $10,000 out of around $1 million, I think it was, just from memory now. And she said, look, he had an obligation to provide for me. The affidavit material in this was, I've used the word threadbare because I was trying to be polite. There were about 3 sentences in the whole thing which had any real meat in terms of establishing any kind of obligation. And those sentences related to a period about 30 years ago when this woman, the plaintiff, had separated from her husband, and she said at that time, my brother gave me some money and bought me some vitamins and bought me some food. So he gave me financial assistance. Full stop. Rashly and naively, I considered that that would be a good claim to try and strike out. So we ran it and we lost. Associate Justice Zammit determined that even though the affidavit material of the plaintiff, and bear in mind the plaintiff should put its best foot forward, even though that material was inadequate, I think that was her word, and it was reasonable for us to have brought the claim, she was going to permit the claim to proceed on to trial on the basis that the plaintiff might like a second go at filing affidavit material and providing further detail beyond the 3 or so sentences that had been provided first up, unforced. It came to the argument on costs, and I had been listening when the decision was given, and Associate Justice Zammit had said that it was perfectly reasonable for the claim to be brought on the basis of the material as it then was. And so I submitted, well, look, we should bear, at worst bear our own costs. We shouldn't be paying the plaintiff's costs. After Your Honour's observations about the state of the plaintiff's material, Associate Justice Zammit ruled that we had to pay the costs because we could have invited, we, the defendant, could have invited the plaintiff to file further material before our application was brought. So, that didn't work so well. Webb and Ryan, I beg your pardon. No, I should deal with Story and Semmons. At the bottom of page 6, paragraph 17, Story and Semmons. This is an application for strikeout, which I was a little bit surprised about when I heard about it anecdotally. Essentially, you got the classic situation where a grandchild claims because the grandchild's parent has died, and then the grandparent doesn't leave anything to the deceased child's side and leaves it to the others. The grandchild was in comfortable financial position. She was 40, no dependents, earned 150 grand a year, had her own home, which was worth a little bit of money, but it was subject to a mortgage of about 230,000, had 100,000 in super. She was comfortable. But when you look at Unger and Sanchez and cases like that, where the successful plaintiffs had net assets in the millions of dollars, you wouldn't have thought automatically that she would be locked out on the basis of no financial need. That was the basis upon which the defendant proceeded, and the defendant failed on that because of those cases such as Unger and others which show that you can have quite a lot of money and still have a viable claim. The interesting part about this case, though, is that when it went on appeal, it was heard by Justice McCauley, and he dismissed the appeal and said, no, the case can go on, no real surprises there. But the comments that he made of interest to us, and they're only in transcript, he didn't provide a written judgment, unfortunately, is that he said Part 4 cases are particularly ill-suited to these kinds of strikeout applications because they're also discretionary, And it may be the case that in many cases, even if you can establish that there's no real prospect of success, the plaintiff will be able to use Section 64 of the Civil Procedure Act to say that it is otherwise in the interests of justice for the case to continue. So there's a proviso to the strikeout. And that was another shot across the bows of any attempt to strike these applications out. Webb and Ryan, on the bottom of page 7, was I described that again tactfully as a particularly unusual kind of claim. The deceased and his late wife basically ran a small business with the plaintiff, the first and second plaintiffs. The deceased and his wife didn't have any kids of their own. They were all shareholders in a company that ran a small business. The first and second plaintiff had children of their own, and those children in turn became close to the deceased and his wife because they allege, and I don't think the matter's settled yet or gone to trial, that they had a sort of, even though they had their own parents, they had a kind of close, unusually close parent-child relationship with the deceased and his wife as well. So it was particularly unusual relationships to base a claim on. There was an application to dismiss it, and I successfully defended it. That was Associate Justice Zammit again. But the interesting thing about this case is a lot of the reasoning or a lot of the motivation for Associate Justice Zammit's decision seemed to me to be that the application to strike this claim out was brought very, very late, after there'd been a mediation and, get this, 30 affidavits filed. 30 affidavits. So, being an advocate and grabbing anything I could, I said, well, look, look how much money's been spent. They could have done this way back then. They waited. 30 affidavits, mediation, all that expenditure, now they try and strike it out. That's another reason not to. And she didn't, she agreed. So the point that I took from that case is that it is safer, if you're going to make one of these applications, if you can be bothered, to do it as soon as you can before money has been expended. And that will also remove the argument that it's in the interests of justice under Section 64 for the case to continue because so much money's been spent so far. On page 8, there was a fascinating one, paragraph 20, the estate of Polly. I was chatting to Richard Phillips one day, a very, very good operator in this area, and he said, look, I've got this, I'm defending this claim. It's a claim by a second husband. He's got $3 million worth of assets. He's making a claim against his wife's estate. She's only got $700,000 and she leaves it all to her 3 kids who are in financial need. I'm going to strike this out on the basis that he's got no financial need. And I said to him, I hadn't heard of this case at that stage. I said, well, yeah, that seems like a very sensible idea. Try and strike it out. Funnily enough, and I can see Lorraine Seacon smiling there, I get the brief to defend it. I'd had nothing to do with it beforehand, I might say. And we ran the application in front of Associate Justice Randall. It was very, very clear from about 3 minutes in that he was not going to dismiss this claim summarily. Now, it seemed to me that Richard had quite a good argument. I mean, if you've got $3 million of your own and there's a $700,000 estate that goes off to 3 children in financial need, what is your financial need in the scheme of things, weighing everything up? I thought he had a very sound argument. Associate Justice Randall said, look, Mr Phillips, this is a husband. Yes, Your Honour. This is the kind of claimant who would ordinarily be owed an obligation. Yes, Your Honour. Well, without cross-examination, without weighing everything up, asset-rich, income poor, all that sort of stuff, I don't think I should strike it out. So he didn't strike it out. So that's another one that, another claim which survived. The second claim that I had tried to strike out is seen at paragraph 21 in the matter of Colville and Edmonds. This was a claim by a niece against her wealthy aunt's estate, and I think Georgie successfully mediated this very recently. Auntie had about $2 million in her estate. The niece got nothing. The niece's sister, just to make things a bit more bitter and twisted, had been given $1 million. And the niece, this particular claimant niece, had in previous wills, and remember that, previous wills, had received something between $100,000 to $300,000 by way of bequests. She was living interstate. Her aunt was in aged care accommodation in the southeastern suburbs somewhere. So this niece couldn't see a lot of her, though it was, you know, they appeared to have a good relationship, and she came down and saw her, and she did, you know, nice things that nice nieces should do. So anyway, the deceased dies, and the niece, of course, brings a claim. Now, the Plaintiff's Counsel did not submit that there was a parent-child relationship or anything like it, but he said it was a close relationship nonetheless. It seems from our reading of the 20-paragraph judgment, which was, I might say we waited 9 months for, so that's another reason to think about whether or not you're going to actually bring one of these applications. It seems from my reading of that Associate Justice Randall decided that the relationship was good but not particularly close. But long story short is that he felt that the claim was not hopeless because the niece had been included in previous wills. Now just think about that for a minute. If someone is generous and sticks them in a will, sticks someone in a will and then decides that, you know, things have moved on or they don't want to leave them anything anymore and takes them out, the very fact, on the strength of this reasoning, the very fact that they have previously been included can be employed as a factor in the making of provision. That was based on a New South Wales case, the case of Mitrovic, which I refer to on at the bottom of page 9. You can have a look at that. But that case occurred in a very different legislative situation. In New South Wales, if you're a niece, you have to show two things. You have to show either financial dependence or being a part of the household, and then on top of that, you've got to show factors warranting the making of provision for you. So it's not, there is more to it than just the factors warranting. And the point of the Mitrovic case was that one of the factors warranting was that a niece had been previously included in a will. But the point of distinction is that that niece had also lived with the deceased and had a very, very close relationship with the deceased. So you had a substratum of a very different kind of relationship, and the cherry on the top was previous inclusion in a will, which was one of the things that the judge took into account in New South Wales in determining there should be some provision made. This decision, it seems to me, has isolated that one factor and used it as a trigger to say, just because there was provision in a previous will doesn't mean that the claim is fanciful. I advised an appeal and the client declined. It had been some 9 to 10 months since the application had been heard before we got the judgment, and we went off and settled it on a commercial basis, as I say, a few weeks ago. But that's something for people to think about. There is another decision that hasn't yet been made. I think it's Ricky Wells and Richard Phillips argued some strikeout or other. They don't have a decision yet. That was argued in August last year. It's not come in. So all in all, my view is that unless the claim on its face is self-evidently ridiculous or self-contradictory, don't bother. It's not worth it. All you will do by bringing an application to strike out and losing, as the trend seems to be, is encourage a plaintiff with a marginal claim that they've got the endorsement of the court when they get to mediation. So I think that is an opportunity which has effectively, pardon me, been lost. Discretionary matters. I'm at the bottom of page 11. How am I going for time? I've got 5 minutes. Thank you, Michael. All right, well, look, let me just do a little bit of skating. You've got a full text paper. It's worth reading the cases I'm not going to talk about. I'll just talk about a couple more. Bruce and Matthews at paragraph 27 on page 13 is extremely important. I give you the detail there and I won't go through it now because, you know, I just can't in 5 minutes. But the point of that case, it seems to me, is that you've got the strongest statement that I can remember in recent years on freedom of testation. What Associate Justice Daly found in that case was that the profoundly disabled plaintiff, who took equally with 3 siblings in a very small estate, should fail in his application. And she did that despite the fact that she assessed that appropriate provision for him would have been about $100,000 and he only got $70,000 under the will. She had quite a reasonable and a proper basis for refusing the award of further provision because the jurisdiction is ultimately discretionary, and there is a discretion as to whether to make provision at all, even if you think that there's been a breach of moral duty. And essentially what she said is that, look, given the fact that the 3 other beneficiaries are in dire financial straits, and given the fact that $70,000, which he got under the will, is actually fairly close to $100,000, I'm not going to make provision. So the plaintiff lost. That is worth remembering, that case, and it's worth having a bit of a look at. Estrella and McDonald has some interesting observations about evidentiary matters in same-sex relationships. For instance, in establishing the relationship, you obviously haven't got the public declaration that comes with marriage. And you might also expect that people are more guarded about their relationship in public than perhaps a heterosexual couple at this stage of the game. That's an interesting thing to look at. Extensions of time. Basically, the Corbett case I won't talk about. The Stanley and State Trustees case is interesting. Justice Kay dismissed an application for leave out of time, even though he said that there was, probably an arguable claim there, simply because the claimant had changed his mind about whether to bring a claim or not. He'd been given an extension on the 6 months to bring a claim, had decided not to, then he turned around later and said, no, I'm going to now. And it was a small estate, and Justice Kay locked him out. The last heading, and this is something that I will take a minute on because it's important, is on page 22, and it talks about costs. Just to set an unhappy little context, this book here I'm holding is rather unpromisingly entitled Bleak House Revisited, Disproportionality in Family Provision Estate Litigation in New South Wales and Victoria. And it's produced by Professor Vines for the Australian Institute of Judicial Administration. I know that the Victorian Law Reform Commission now has a reference to look at costs in family provision proceedings in Victoria. I'll just leave you with that. If the Law Institute wants to make a submission on that, I think that would be a very good idea. I think the bar will too. In terms of costs though, in terms of the cases which have been decided, there's a couple which are important. At paragraph 42 on page 22, I talk about the Collette and Knox case. And again, you've got full details there, but the gist is this. If you are a defendant defending your own interests in the will, you might be a sole executor and beneficiary, do not think that you can just fight the litigation to the nth degree, spend as much money as you want, and the judge's hands will be tied and give you your costs under the usual trustee's indemnity. Do not think that, because that did not happen in Collette and Knox. We don't know what did happen, but the judge's comments made it fairly clear that that was not going to happen. So that's well worth thinking about and remembering when you're defending this kind of litigation, especially if you're defending your own interests. The other decision which is important is Simon Gardner's decision in Re Khan. That's found on page 24 at paragraph 46. The very brief summary of facts in that is you've got 2 brothers fighting over Mum's estate. Mum's estate has nothing but a house in it. One brother doesn't own anything and he's living in the house, and Mum wants him to have the house to live in. The other brother has a property portfolio, lots of debt but lots of assets. His net position was about $1 million, I think, including super. So he had net $1 million. His brother had nothing. He brought a claim because he said, I've got nothing, it's unfair. And if you have a plaintiff or a proposed plaintiff sitting in front of you and using the word unfair, just be very careful that it doesn't find its way into the affidavit. Because this area of law is not about fairness at all. It's about breach of moral duty. Anyway, the plaintiff with the brother with the property portfolio brings a claim thinking to himself, against advice, and I know this because he was very well represented, I can tell you that. He's thinking to himself, I don't get anything, it's not fair, I've got to get something. Brings the claim, he loses. When the reasons, the substantive reasons are given, Associate Justice Gardiner says, well, look, it's probably just bare own costs, or costs lying where they fall. I think that was what he decided. He certainly wasn't thinking of making a costs order. And then there was a full hearing on costs. And the upshot of all that can be seen on page 27, where I've extracted some of the judge's reasons. He had a very, very good hard look at interstate authority on costs, noted what had tended to happen over the years. That is, if you bring a claim and you lose, you probably bear your own. Sometimes you get paid from the estate, but more likely you'll bear your own costs. He then made the comments that I've outlined on page 27 of my paper. And I'll just read a little bit of that because it's worth emphasising. If a plaintiff thinks that there's little risk and much to be gained from making a claim, however weak, because the plaintiff is very likely to get his costs out of the estate, nothing will discourage weak claims from being made. Paragraph 29. An executor has to defend such a proceeding, and even the most spurious claim will involve expenditure of considerable costs because, absent some extraordinary feature, the estate's costs are routinely paid out of the estate on a trustee basis. He then goes on to talk about section 97(7), which enables frivolous and vexatious claimants to be punished in costs, but also says that even when a claim is not frivolous and vexatious, it still costs the estate a packet of money. And because of that, sometimes, even if it's not frivolous and vexatious, an unsuccessful plaintiff should pay. And that was a point that Justice Byrne made in Bentley, Bull and Brennan some time ago. He then notes that the position is particularly unsatisfactory in small estates. And by the time this litigation had run, I think it was, $800,000-900,000 estate was significantly less. So he then proceeded to find that the plaintiff's claim in this case was had no real prospect of success and shouldn't have been brought. He said, look, he was financially much better off than his brother, had a net asset portfolio of about $900,000, had a good income, I think it was in the mid-100s or something like that. Yep, joint income of 155. And his brother, if he didn't get the provision that the mother had intended, the house, would have absolutely nothing. So he said that the case shouldn't have been brought at all. He also said that in cross-examination, I think the plaintiff had admitted that some of the provision that he was after was to help him service his liabilities on his property portfolio so he could keep that and pass it on to his children. And that didn't go down terribly well, and that was the subject of comment in the judgment as well. And also, Associate Justice Gardiner noted that dread word unfair had been used, that the plaintiff thought that no provision was unfair. So the end result was that after losing the case, the plaintiff had to pay the estate's costs. Well worth remembering. And I think it's part of a trend. Unfortunately, in the past, judges have been loath to, when they've made cost orders at all, they haven't actually given written reasons on very many occasions. I reckon that might change if the law doesn't change anyway after the Law Reform Commission has a look at things. The only other point I'd like to make is at paragraph 56, where I talk about call-to-bank letters. When I draw call-to-bank letters now, I refer the other side to the specific paragraphs in Re Khan and also the case of the Court of Appeal in Forsyth and Sinclair, where there were views and great concern expressed about the level and impact of costs on estates in TFM litigation. Justice Habsburger was a member of the Court of Appeal in that case, and in other matters I've heard him, when he's sitting in the trial division, mention the costs concerns expressed in Forsyth and Sinclair on at least 2 occasions, probably 3. So it is very much in the judges' minds. So the only the lesson to take from all that, I think, is that costs should always be carefully examined. They should be proportionate, and also there should be absolutely no illusion anymore that they will come from the estate win, lose or draw. And that's all I have to say. Thank you for your attendance.
Any questions of Andrew before I tell you what actually happened very briefly in Jarndyce and Jaundice? Any questions from Andrew? For Andrew? All right, ladies and gentlemen, you can see now that nothing much has changed. Fighting over the spoils by family and honorary members has been occurring since, as I stated earlier, the 17th century. The ending of the Jarndyce and Jaundice case is very simple. When the case ended, towards the end of the chapters of Bleak House, people came out of the Chancery Court with piles and piles of papers. The papers were in bags, they were in suitcases. The clerks of courts laughed. No one could believe that finally, after all these years, Jarndyce and Jaundice was coming to an end. The litigants were exhausted. As I said earlier, many had died. Many had become mothers and grandmothers during the ensuing suit and the litigation. But the end of the case, what was indicative of the case, and I quote, as Mr. Allen said to Mr. King, "Do you understand that the whole estate is now found to have been absorbed in costs?" And that, ladies and gentlemen, is the moral of the story of Jarndyce and Jaundice, and the importance of these 2 papers that these 2 gentlemen have given. Be aware of this area of the law, be very conscious of costs, because the outcome, as occurred in Jarndyce and Jaundice, is that no one really won at the end of the day, and even the lawyers towards the end of the book were physically and morally exhausted by a piece of litigation that went on for decades regarding the spoils of a deceased estate. Thank you for coming, ladies and gentlemen. I thank Michael Green and his staff, and we'll see you at the next breakfast. Thank you.